A company signs a deal. The numbers look perfect, but one question remains. Is the deal fair or influenced? Because in corporate governance, relationships can create risks. And that's where the law steps in. Section 188 of the Companies Act 2013, a provision designed to regulate related party transactions. Core rule: no company shall enter into a related party transaction without prior approval of the board of directors. Types of transactions: these transactions include sale or purchase of goods, property transactions, leasing arrangements, availing or rendering services, appointment of agents, office of profit, underwriting. Purpose of law: why regulate these transactions? To prevent conflict of interest, to ensure fair pricing, to protect shareholders, because connected parties can influence decisions. Concept line: this law ensures fair dealing in connected relationships. Shareholder approval: when transactions cross prescribed limits, board approval is not enough. Shareholder approval becomes mandatory. Risk logic: because higher value means higher risk, higher scrutiny, higher accountability. Voting restriction: here's a key safeguard. Related parties cannot vote on such resolutions. No influence, no control. 90% relaxation: but what if most members are related? If 90% or more members are related, the voting restriction is removed. Otherwise, decisions become impossible. Arm's length exemption: if the transaction is in the ordinary course of business and at arm's length, then Section 188 does not apply, because fairness is already ensured. Holding and WOS exemption: transactions between a holding company and its wholly owned subsidiary do not require shareholder approval, because economically they operate as one entity. Practical story intro. Let's understand this with an example. Mr. Prasad Khopkar enters into a transaction with his related entity. Example 1. Company purchases goods from his related party. Board approval is required. Explanation 2. Large transaction, 50 crore rupees. Shareholder approval becomes mandatory. Example 3. Being a related party, he cannot vote in the general meeting. Example 4. If goods are sold, curious, at market price, no Section 188 compliance required. Example 5. Transaction with curious wholly owned subsidiary. No shareholder approval needed. Disclosure rule: all related party transactions, serious, must be disclosed in the board's report with proper justification. Voidable contract: if approval is not taken, the contract must be ratified within 3 months. Otherwise, it becomes voidable. Recovery of loss: if the company suffers loss, the director must compensate the company. Penalty: violation leads to penalty. Listed company 25 lakh rupees, other company 5 lakh rupees. Strict enforcement. Rule 15. Conditions: before approval, board must know related party details, nature of relationship, pricing transaction value, and the interested director must not be present. Key takeaways: Section 188 ensures approval before transaction, transparency in decisions, no influence by interested parties, accountability for misuse. Merit trick: remember this simple formula: BSVP, board approval, shareholder approval, voting restriction, penalty. Exam insight: always remember, ordinary course plus arm's length means exemption. No ratification within 3 months, contract becomes voidable. Final impact line: in corporate governance, relationships are inevitable. but fairness must always be ensured. If this made Section 188 simple and clear, like, share, and subscribe to Corporate and Securities Law Compass. Navigate law with clarity and lead with confidence. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India (ICSI), or any organization or listed company with which the speaker may be associated, shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information (UPSI), confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations, 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.